freedom of speech,
fundamental rights,
freedom of conscience,
academic freedom,
freedom of press,
and the right to listen.
You're listening to So to Speak, the free speech podcast, brought to you by FIRE, the Foundation for Individual Rights in Education.
Hello, I'm Nico Perino, and welcome back to So to Speak, where every other Thursday we take an uncensored look at the world of free expression through personal stories and candid conversations. On today's show, I'm taking a back seat while our candid conversation is led by Wall Street Journal Supreme Court correspondent Jess Bravin, who will interview the new national legal director of the ACLU and Georgetown law professor David Cole. Earlier this month, it was announced online that we would be the new home for podcasts of the First Amendment Salon. The First Amendment Salon is a quarterly gathering of members of the First Amendment community for a 90-minute discussion with some of the community's leading thinkers concerning a timely topic related to freedom of expression. Today's conversation between Jess Bravin and David Cole is the first of the salons that we will host on our podcast. This particular salon took place on the evening of December 8th at the law offices of Levine, Sullivan, Koch, and Schultz in Washington, D.C., with a group of folks at LSKS's offices in New York City joining by video conference. The conversation is a meandering one, touching upon flag burning, campaign finance laws, the hot topic of the moment, of course, which is fake news and what can be done about it, and much, much more, including what the future may hold for the ACLU in the era of Donald Trump. After about 45 minutes, Bravin then opens up the conversation for audience questions. But before I turn the podcast over to Bravin and Cole, I want to extend my deepest thanks to the First Amendment Salon's co-chairs, Ron Collins, Lee Levine, and David Scover, and the members of the First Amendment Salon's advisory board for giving, so to speak, the exclusive right to feature the salons on our podcast. I should also note that as part of this partnership, videos and archives of past salons can be found within the Special Collections section of FIRE's new First Amendment Library, which is located at thefire.org/first-amendment-library. So without further ado, I present to you Wall Street Journal Supreme Court correspondent Jess Bravin and ACLU National Legal Director David Cole.
It's great to talk to David because, like some of us, have taken jobs that maybe turned out to end up being a little different than we perhaps anticipated. If you're incoming as the legal director for the ACLU, you may have had a particular kind of docket in mind when you accepted the job earlier in the year. It might have been, finishing up some loose ends involving, Eighth Amendment perhaps, or other sorts of things that were kind of lying out there. But it looks like the nation responded to your expertise and is going to help you have a docket that is more in line with some of these First Amendment questions that you have applied. So let me just start out by asking you, David, looking forward to the next several years, the ACLU is a constant participant in litigation in lower courts and at the Supreme Court. It has a very influential voice. Even Justice Thomas several weeks ago specifically said he always reads the ACLU briefs when it involves questions of civil liberties. So you certainly have an audience there that's interested in what you have to say, even if it doesn't always agree with you. What do you anticipate your agenda is going to be like over the next several years?
Well, thanks, Jess, and thanks to Ron and Lee for having me here, and thanks to all of you for coming. I feel somewhat humbled in a crowd of people who are so versed in First Amendment law. But here we go. So when I took this job, which was in the end of the summer, actually, I thought, what a fantastic job. I went to law school in the 80s, and I was taught by professors whose vision of constitutional law was framed by the Warren Court, and they taught me that vision of constitutional law, and then they spat me out into the world, and I became a constitutional lawyer, and for the last 30-some years I've been litigating constitutional cases and with a court that is majority conservative. And I thought, oh my gosh, for the first time in my career, I'm actually going to have the luxury of speaking to a court that might be sympathetic to our concerns, might be more open to our points of view, and what an opportunity that is.
And let me just interrupt for a second. For people who are listening on the podcast, that's because many people expected that either President Obama or Hillary Clinton would fill the vacancy on the Supreme Court and would shift perhaps the jurisprudential alignment to a five-member liberal bloc, and that doesn't seem so likely with Donald Trump being the appointing authority. So that's for our listeners who
understatement of the week. So we had memos being written about where we could move the constitutional doctrine forward in a liberal majority court. Those are in the trash now. And it's a whole different world. And I didn't put a little, codicil in my contract saying, if Hillary Clinton doesn't win the election, I'd rather stay in my job. So here I am. But I actually, feel like it's a tremendous privilege. I mean, what better opportunity than to wake up every day and think about how to protect our fundamental liberties from the kinds of threats that Donald Trump has already suggested that he will bring to bear. So in some ways, I'm happy to take on the challenges. They're different challenges than what I considered, but I'm happy to take them on. I'm also happy that Justice Thomas reads our briefs, reads the ACLU briefs. My understanding is that at that same event was on his 25th anniversary on the court or something. They asked him, which amicus briefs do you find useful? And he said the ACLU's amicus briefs, and I thought that was good. Second question was, which briefs do you find particularly unhelpful? He said law professors' briefs. Maybe the ACLU made a mistake in hiring a law professor to head up their Supreme Court project, but there we go.
Well, that's true. He referred to law. Were you there too, David? I think it was law professors for goodness everywhere. So some sort of fanciful self-created group of opining. But you said the threats that you think Trump will have for the First Amendment and also some of your other areas. But what specifically? Can you tell us what are you specifically? The Pentagon, they've got a lot of planners who try to anticipate threats to the nation. I assume you are anticipating.
Yeah, we pretty much model ourselves on the Pentagon, the ACLU. So we have 4-star generals and the like. The one thing that's hard that we can say for sure is that it's really hard to predict what Donald Trump will do. So we are gearing up as best we can. There are some areas where he's been very clear about what he wants to accomplish and what his views are, and other areas where it remains to be seen. So and I would say the principal threats are at least thus far not in the area of the First Amendment, flag burning tweets notwithstanding. I think the principal areas of concern are immigration, reproductive freedom, national security, surveillance, and the like. In the specific areas of speech, he's certainly shown no respect for the First Amendment, although that doesn't really differentiate his attitude.
He seems to exercise his First Amendment rights all the time.
Well, yeah, he does, but he doesn't respect your First Amendment rights. For example, he seems to have very little respect for the rights of the press, for the rights of those who criticize him, And you know, and that's troubling in someone who's going to become the most powerful person in the United States and you know, arguably in the world. And you know, how that will manifest itself in you know, whether he will sort of put his demagogic threats against flag burners and against the press into some kind of formal hard power measures, that remains to be seen. But I think he'll continue to engage in the demagoguery because that's what plays to his audience, and that has a negative impact, you know, in and of itself. But you know, if it turns into hard law measures, then we will stand ready to fight back.
Now, let me read you a quote here. We're suggesting there's been a tear in the First Amendment right now, and it's widening. I really do believe that the framers of the Constitution put a free and independent press of the First Amendment to protect the public's right to know. And the only way you do that is to protect reporters' ability to keep certain sources confidential. That was a lawmaker discussing a federal press shield bill. Do you think that kind of attitude is going to have any weight in the Trump administration? I say that to read you the full quote. Mr. Pence said that some were surprised to see him and other conservatives championing a press freedom bill. Quote, it's one of those things that's a little counterintuitive for a cheerful right-winger to be involved in, he says. But we're suggesting the only way you can patch it is to do as many states have done and pass a federal statute that clarifies the boundaries. Do you think that that you're going to see a more nuanced conversation when you have such an ally in the vice president's chair?
I hope so. You know, and it's certainly encouraging that Mike Pence took that view at that time, and the ACLU supports a federal reporter's privilege law. And you know, I mean, the reality is that with respect to First Amendment matters, there's often considerable space for bipartisan consensus. It's not necessarily a Republican-Democratic issue at all. So you know, I don't see any indication that President-elect Trump has very much respect for First Amendment freedoms, but I think there are significant people in the Republican Party who do, and the only thing that's going to move forward are going to be those things around which there's bipartisan consensus.
So you mentioned his lack of what you think is the president-elect's lack of respect for First Amendment rights. We saw recently, just the other day, yesterday, he responded to criticism by a union leader in Indiana, and they got into sort of a back and forth. He didn't threaten him. He simply said the guy's wrong and they should lower their dues that they charge the members of the steelworkers local. But there's been some collateral results apparently with other people, you know, picking up the mantle and being threatening or critical. Mm-hmm. This sort of thing. What is that a problem, or is that just a more robust debate that the president-elect is encouraging?
So you know, I think I'm all in favor of robust debate, and I think that you know, that's what the First Amendment is designed to protect, and that's what the ACLU believes in. I think as President of the United States, there's a responsibility to understand the power of your position, of your voice, and to exercise it responsibly. I think most presidents have done so. I think George W. Bush did that. I think President Obama did that. I have not seen that from President Trump, and I don't think it's unconstitutional, but I think it's deeply disturbing. He should be setting an example for the nation, and I think the example he's setting is unfortunately the kind of example that's encouraging all kinds of vituperative, vitriolic venting, which leads to things like the event at Comet Pizza here in Washington, D.C. over the weekend, where because fake news was distributed about a alleged plot by Hillary Clinton to have a child sex ring in the basement of Comet Pizza, a self-appointed vigilante comes out with an assault weapon and enters Comet Pizza. I do think the president has to be more responsible about what he says. Just as I think a president of a university has to be more responsible about what he says. I think, I taking this job as the National Legal Director of the ACLU, I have to be more careful about what I say than when I'm just a lowly professor who has, no organizational, responsibility behind me. The President of the United States has that responsibility. He's shown, absolutely none. The notion that
you realize he may be watching the podcast.
Tweeting right now.
Isn't that him right there? No, the notion that the person who's about to take the most powerful position in the world, first of all, wakes up and tweets is remarkable. Then that he tweets that people should be thrown in jail and have their citizenship stripped for burning the flag when the Supreme Court has ruled that that's constitutionally protected, and when 20 years ago, and when 30, 40 years ago, 50 years ago now, the Supreme Court ruled that you can't strip people of their citizenship regardless of what they do, whether it's speech or conduct. That's just deeply irresponsible.
Well, as many people point out, Hillary Clinton was a sponsor of a bill that would have, in some circumstances, criminalized desecrating the flag. So it seems that there's usually a very, very small minority of legislators who will vote against a bill on that issue. So is it really fair to single out Mr. Trump?
So it is the easy thing to do for a politician to demagogue on flag burning. That's for sure, and we saw that. When we won the Texas versus Johnson, the decision came down, as they always do, right at the end of the term. And of course, the end of the term is right before the 4th of July holiday. And probably a number of people in the room remember this, but Congress was set to go out for the 4th of July holiday. They stayed in session for 2 days so that virtually every member of Congress could get up and say how outrageous this decision was. And then the only debate thereafter was between the Republicans, who believed that we should amend the Constitution to excise flag burning from the First Amendment, and the Democrats, who believed that we should enact a cleaner statute to make sure we could put flag burners in jail. It shows that this is the easy thing to do for a politician, is to be demagogic. The hard thing to do is to stand up for principle. But I want my leader to stand up for principle, not to be a demagogue.
We could, of course, spend a whole night talking about flag burning, but I wanted to make sure we talked a bit about campaign finance before we get back to more incendiary topics. Little First Amendment joke there. The ACLU has subscribed to the Supreme Court's view and encouraged it to end some campaign finance regulations, agreeing that it constitutes a restriction on speech. I'm wondering, is that it seems likely that a Trump appointee will continue that line of cases if they are indeed cut from the mold of Justice Scalia. So would you see that as a bright spot, in contrast to some of these other worries you've expressed?
One of the things that President Trump and Hillary Clinton both agreed on was that the campaign finance system is broken and needs to be fixed. So who knows? I think the ACLU's position on campaign finance is that it is a First Amendment issue. It's a serious First Amendment issue. Whenever you empower the people who hold office to set the rules for how the contests to replace them are run, there are real concerns. And when you limit the expenditure of money for purposes of political campaign activity, that is something that ought to trigger First Amendment scrutiny. I've always subscribed to that. I continue to subscribe to that. I think that the question going forward really will be whether the court sees a broader set of compelling state interests that justify restrictions on campaign finance. Thus far, it's been very restrictive in limiting it to quid pro quo corruption and the appearance thereof, and nothing beyond that. And the ACLU supports that view. They think that other justifications that have been offered raise serious concerns. But that's an issue, about which there's a lot of reasonable people disagree, including within the ACLU, including former leaders of the ACLU. So, I think I think we'll see how it goes. But I've sort of taken off my ACLU hat. I've long taken the position that, given how unpopular Citizens United is, something like 80% of the American people think it was wrongly decided. I'm not sure what percent of them know what it decided, but they think it was wrongly decided. And then even 70% of Republicans think it was wrongly decided. I don't think a Supreme Court decision is likely to stand with that kind of popular condemnation for all that long. And there are significant civil society groups that are working to try.
What percentage did you say was on board with that flag burning decision?
It's not 80%, 70% at all. Here's my view. My view on flag burning is that members of Congress, as long as they know that the Constitution will not be amended, they will vote in favor of amendment. So when the issue
just write a book, Hiller, about this whole thing.
Yeah, I did. But when the question of should the First Amendment be amended to excise the flag burning went around, 49 out of 50 states approved resolutions to do so. The only one that didn't was Vermont, state of Bernie Sanders. They then went to the House and got way more than 2/3 support in the House. I think closer to 3/4 support in the House. But it failed in the Senate several times, and often by 1 or 2 or 3 votes. And I think my sense is that many members of the Senate and the House believe that we should not be amending the Constitution to target one particular form of protest. But as long as it's not going to happen, the easy thing for them to do is to vote for it, and then they don't have to take the flak. But when push comes to shove, there will be enough who will vote to stop. And that's all the more. That was true in the immediate aftermath of the flag burning decisions. Those decisions have now been around for 25 years. They have been cited with approval by every member of the Supreme Court. I think it's highly unlikely that we'll see any action in that area. That it proves a real threat.
One of the things that Mr. Trump specifically said was he talked about opening up the libel laws. What does that mean to you, and what do you think? I would assume in a room with attorneys, they'd say, "Right on," because But what do you think that means, and what do you practically, and what was he talking about?
I'd love to. I think maybe you should have President-elect Donald Trump for your next salon, because asking what in the world did he mean by opening? How does the federal government open up libel laws? These are state law causes of action. There's a constitutional overlay that is set by the Supreme Court. It is not determined by Congress or the president. So he may be unhappy with libel laws, but I don't. And he may use the bully pulpit to urge states to try to make suits for libel more easier to prevail upon. But I honestly don't know what he meant by that. Do you?
Well, we haven't discussed that yet, the president-elect and I. But No, I know as much as you do. I mean, he did comment recently that it was mentioned to him that given his own sometimes pugnacious form of expression, if you opened up those kind of laws, it might expose him to some liability. So he thought.
But he'd love to be able to sue Alec Baldwin.
Right, and I think vice versa. So, and imagine that in court where both of them are.
I don't know. Trump is Alec Baldwin's ticket, so
yeah, that could be. So you don't know. So you're not expecting anything really in the libel front.
I don't know. I mean, this group may have a better sense of what we should realistically expect, but it's hard to translate. I mean, sometimes it's hard to translate what he says on the stump to actual concrete action, and we'll only really know what he intends in terms of concrete action on January 20th.
He's had his Twitter account, he's had his podiums and stadiums and whatnot as a candidate. When he is in the government, he's going to also have a vast information providing apparatus. The government puts out a lot of information, and the government has a fair degree of leeway for its own speech. What do you think that given his own background as someone who has promoted various commercial products, he recently had a settlement about the way he promoted his Trump University seminar and what it actually provided. When you have someone who sort of he's a salesman, and he's a you use the word demagogue. I of course won't characterize him that way, but do you think that poses any interesting issues or challenges for the government's own information apparatus? I mean, it's sending out public service announcements and messages. It has international broadcasting, Voice of America. It has all ads on buses, ads on television, statements, reports, websites. Yeah. What do you think are the First Amendment implications there?
Well, I think we have to be vigilant there, but I also think that there are some sort of structural constraints. So the legitimacy of the government-funded voices turns on their not being blatantly political. Voice of America, loses its legitimacy if it's not seen as engaging in some kind of, meaningful journalistic enterprise. And I think that those norms will play.
You think they'll be very strongly respected in the Trump administration?
No, I don't think they'll be respected in the Trump administration. I'm not sure that Trump. Well, number one, the first question is, will Trump care what Voice of America is doing? I'm not sure he'll care, and will the sort of career people in Voice of America be concerned about their reputations, about their credibility, about their legitimacy? In the same way, I think legitimacy is a powerful constraining force. It's a constraining force on the press. It's a constraining force on the court. It's, I think, a constraining force on government agencies. And so, and our job is to criticize. I think our job, meaning the job of the citizenry, is to criticize government when it engages in these actions, whether or not they're formally unconstitutional, to underscore the threat to legitimacy that these actions pose. And I think if enough people are vocal about it and offer criticism, we will limit the kind of damage that he does. I don't know what damage he will do, and I worry about his tendency to sort of target his enemies and go after them with vitriol. But I think we have to push back. And the one thing that I am very encouraged by in the wake of the election is the extent to which people from all walks of life have come forward and said, we're concerned, we want to do something about this, we want to be mobilized. I mean, the The law faculty at Georgetown, held a meeting to decide what we're going to do to respond to Trump. The law faculties of
Well, the Republic is safe then.
No. I'm just giving you the law faculties of all of the New York law schools are coming together to do. And I emphasize law faculties partly because that's the world I'm coming from. But I'll tell you, this is not a world that gets engaged in. This is a world that largely sits back in their armchairs and criticizes and is very cynical and very wise, but does not get engaged. They're getting engaged. Students are getting engaged, want to do something, they revived the ACLU chapter at Georgetown. People are supporting and joining groups like the ACLU, supporting Planned Parenthood, supporting environmental groups. I mean, just to take the ACLU as an example, before Donald Trump was elected, we had about 500,000 members and donors, 500,000. Today, we have over 750,000.
How many electoral votes is that?
No, but look, it's not about electoral votes. Like my most recent book, Engines of Liberty, is called the power of citizen activists. And the point is that what changes constitutional law, what enforces constitutional law, is of course the formal structures of government, the court, the separation of powers, Congress, the federalism, etc. Right? Of course, those are enforcers of constitutional principles. But the real drivers of constitutionalism, I think, are people. When people get together in organizations committed to particular constitutional visions and work strategically and insistently over a significant period of time, they can make significant changes. So people say to me, well, how are we going to stop Trump? He didn't get the majority of the American people, but he has a Congress that is Republican. He is going to have a court that is a majority Republican. Who's going to stop him, right? I say, well, you could have asked the same question about George W. Bush after 9/11. He, for most of the quote-unquote war on terror that he conducted, he had a Republican Congress. He had a court that was not only majority conservative, but actually voted to put him in office in Bush versus Gore. He had not the support of 49% of the voters, but he had something like 75-80% support in the wake of 9/11. The people rallied around him, and he acted as if he could do whatever he wanted, authorizing torture, renditions, disappearances of terrorist suspects, warrantless wiretapping of Americans. But by the time he left office, he had released over 500 of the Guantanamo detainees. The torture program was suspended. Extraordinary rendition wasn't happening. The CIA's secret prisons had been emptied. The warrantless wiretapping program was now under judicial supervision. And what caused that? What caused that, I argue in the book, is organizations of committed citizens working strategically in a variety of different forums to push back against what the President of the United States, at a time of crisis, at a time when in historical periods the President got to do whatever he felt was necessary to make the country secure, and there was and he was forced to curtail, and he didn't curtail those things voluntarily. You read his memoir, and read Dick Cheney's memoir. They don't regret anything that they did, but they pulled all of those things back because of the criticism. So I think when we have majority support, that is against Donald Trump, the fact that he has Congress and the court doesn't mean that we, the American people, can't, if we stand up, if we work in concert with others, push back against whatever threats he poses.
So your side is counting on populism then for victory.
I would say on civil society. Populism. He's got the populism, but I think what we do have is civil society. That is, it's about the power of organizations committed to particular constitutional visions. The ACLU is one. In the book, I talk about the gay rights groups and how they were able to make marriage equality go from unthinkable to inevitable. I also talk about the NRA and its ability to make the individual right to bear arms go from being dismissed as fraudulent by Chief Justice Berger in 1991 to recognized as a constitutional right in 2008. You know, those were citizens groups acting against tremendous odds. And so too the work of the Center for Constitutional Rights, the Human Rights First, ACLU, in pushing back against President Bush. Tremendous odds. Historically, presidents had gotten to do what they wanted. Congress had laid down, the courts had laid down. Presidents were not constrained. This time presidents were. And that was the power of civil society. And I think that's a core aspect of constitutionalism. It's protected by the First Amendment, but it in turn protects the First Amendment.
David, let's talk about the first freedoms in the First Amendment, the religion clauses. How do you expect those to fare under the coming administration, and what do you see as the ACLU's role in protecting those rights?
Well, the ACLU has always protected religious freedom. The ACLU is made up of a national office which has 15 subject matter projects, and we have a religious freedom project. And then, of course, the affiliates, 53 affiliates, one in each state and more than one in California. And they do a fair amount of First Amendment religion work, both Establishment Clause and Free Exercise Clause work. They'll continue to do it. I don't know what the particular threats are likely to be. I think some of them that we've seen already, and they may well continue, are the claims of religious exemptions from anti-discrimination laws, particularly with respect to those who object to marriage equality and the like. And the ACLU has been very active on that front, defending the principle of non-discrimination and defending the rights of gays and lesbians not to be discriminated against simply because someone has a religious commitment to discrimination.
Now, just tell me how we're doing with time, because I can of course keep talking, but I thought we'll have some questions. Keep going.
No, I think you should open it up.
Oh, okay, sure. Well, David, thanks for that sort of overview of a few of the topics. But let's hear what the experts think.
Yeah.
So questions, thoughts for David? Wow, quite a chilling effect.
Well, I'll start.
All right, Lee, please.
You alluded to the events at the Cosmic Ping
Comet
weekend.
Pizzeria.
Lee Levine at Comic Ping Pong over the weekend. I've gotten a number of calls from reporters asking, what's the First Amendment position on that?
Yeah.
And I'm wondering...
We don't believe there's a First Amendment right to go into pizzerias with an assault rifle.
Right.
There's a conduct speech distinction.
That part was easy. But what about the part about the focus,
Fake
focus on
news.
fake news, and that we need to do something about it?
Yeah. So my view is that there is a problem with fake news. And I think there's a problem generally with our siloed, the kind of siloed ways in which people get information these days from and don't confront challenges to that information. I don't think the solution to that is empowering either the government or Facebook or Google to decide what the truth is. I still believe that the approach of the marketplace of ideas is the way you respond to false reports, by making clear that they are false reports. And I think as and it's not.
Well, who does that? I mean, there's some kind of preposterous internet rumor. It's not reported by any legitimate
Yeah.
news organizations. It's not even reported by quasi-legitimate organizations. It just
Yeah.
spreads by itself. Who's going to be out there? I can tell. I mean, I think that we would have at our newspaper very few resources devoted to looking for crackpot theories and then writing articles about how they're not true.
Yeah, well,
so
I was going to nominate the Wall Street Journal because it has a certain credibility, But I don't. I mean, I think the question always is, what is the alternative? And we certainly, I don't think would be comfortable with empowering the government to have some authority who trolls the internet for true and false statements and says, okay, these are true and can be expressed, and these are false.
Yeah, but no one's proposing that. What people are talking about is having the private providers.
Right, and I'm not comfortable with the private providers playing that role either. I think that's giving centralized authority to determine the truth. I fully expect the Wall Street Journal to make editorial judgments about what it publishes and what it doesn't publish. But if you're essentially a common carrier, a platform for communication, I think it's dangerous to.
Well, they do make judgments right now. That's the point. They make judgments through their algorithms about what stories they're going to promote based on their sort of computerized predictions of what will keep people, hooked on their.
And I think it's within their. It's appropriate to decide what they want to promote. That's their. But we're talking about suppression. I think what people have in their mind is somebody out there is going to save us from fake news. I think who's going to save us from fake news is us. I think we have to respond. If you see a fake news, say it's fake. And
how would you know? If you're not,
Well, I mean, I think all of us in this room know that Hillary Clinton was not running a child sex ring under Comet Pizza, and I think we could say as much.
How about opening up the libel laws so Comet Ping Pong can go after people who are saying that? What about that?
Well,
I'm serious. What about allowing when it becomes a very specific attack on some private party,
some business,
individual, or business, or I mean, are there remedies that are adequate right now, or does that have to be explored as a way for people who are victimized by this to?
Yeah. I don't consider myself a sufficient expert to know, whether there's room for expanding liability, but I'm skeptical. I think the more speech, rather than penalizing people for speech, should be our presumptive response, and you have to meet a very high standard before you go away from that approach.
Bob Cormier, just following up on this line, since it's all the rage these days.
Yeah.
If we were to try and seek some solution to somehow verifying official statements or news, wouldn't the next step necessarily have to be finding some way to regulate what people are willing to believe? I mean, how many times have you seen people cite The Onion thinking that it was an actual news story?
Yeah.
Thank you, New York.
Yeah, I think look, I've always thought the strongest argument for a strong First Amendment presumption in favor of more speech rather than regulated speech is not so much the Holmesian free marketplace of ideas will lead us to truth, but the reverse of that. Yes. What is the alternative? Who are you going to give the power to decide whether a statement is true or false and therefore can be communicated, disseminated, or not? I think that is not the kind of power that we ought to feel comfortable assigning to any particular authority, and therefore we have to tolerate the costs. We've always had to tolerate the costs, and in a social media, siloed world, those costs seem scarier. But we've always had to deal with that. And I think it's because there isn't an alternative that we would be comfortable with.
we have a question from New York?
Yes, I have a question. David, you talked about putting on faith in civil society and in people organizing and protesting, but I think we're about to enter a period where we have less tolerance for organizing and dissent and speech than we have seen in a very, very long time. You mentioned the threat of surveillance in your opening statement. That has, to the extent that people are aware of the surveillance, and one of the worst things about it is that it's invisible and so many people aren't aware of it. To the extent that people aren't aware of it, it has a real chilling effect. To the extent that it is apparent to people, it can be extremely dangerous. So I'd really like to hear you talk more about the threat of surveillance to speech and protest and dissent and the kind of organizing that you're hoping will bring us some sort of change, and what can be done about it legally.
So, tell us your name for the podcast.
Jane. Oh, I'm sorry, Wendy Kaminer.
So, so good question. Although I would differ in one respect. I think if people aren't aware of the surveillance, then they're not going to be chilled because they're not aware of the surveillance. If they are aware of the surveillance, then they will be chilled. And if they're afraid of the surveillance, then whether it's there or not, they will be chilled. So, I think surveillance threatens both privacy and First Amendment free expression values, and we have to be very vigilant about arguing for protections against especially dragnet surveillance and surveillance that's targeted on the basis of First Amendment activities. I'm somewhat optimistic about people's about the ability to mobilize people on this issue. When the Snowden disclosures were made, everything changed around this issue. So before the Snowden disclosures were made about the NSA gathering all of our phone metadata, the courts had okayed it. Congress had reauthorized the statute that the NSA was relying on 7 times. President Obama had okayed it. Once it became public and once individuals and citizens and organizations and Silicon Valley raised real concerns about it, every one of those branches of government changed, right? President Obama introduced reforms after his commission recommended them. Congress passed the USA Freedom Act, ending the program, and the courts, the Second Circuit, declared the program illegal. So I think surveillance, because it, particularly broad-based surveillance, threatens all of us. I think it's the kind of thing where you actually can mobilize people around defending it. And at the end of the day, if we can't, then we lose. If we can, then I think we can prevail. And I do think that we have a very strong culture of the propriety of dissent and the impropriety of government singling out people because they dissent. Doesn't mean it doesn't happen, but I think we've gone through many periods where that has been a core feature of our government. The reality is that in the post 9/11 era, it wasn't so much. Right? Even though there was a tremendous amount of fear, a tremendous amount of concern, speech itself was not targeted. And I think that was because, and that was not true in World War I, not true in World War II, not true in the McCarthy era, not true in the Civil Rights era. But it was, it was more true. And so I think we have learned some lessons, and those lessons undergird a kind of cultural commitment to free expression. And again, the institutions that exist, like PEN American Center and Reporters Committee for Freedom of the Press and the First Amendment Salon and the ACLU and the Center for Constitutional Rights, these institutions, I think, play a critical role in sort of nurturing that and reinforcing that. And the press, right, which has a strong self-interest in in nurturing this value. And I think it's a pretty strong value. I am optimistic that on that set of issues, we can and will push back if people continue to be engaged, continue to push back, and are not chilled in the way that you described.
David, I'm surprised to hear you say that speech wasn't targeted, because didn't you litigate the material support case?
Yeah, I was just going to throw that out as one caveat, which is in the area of material support. Yeah, I mean, I think that was a, but even there. So we litigated a challenge on behalf of human rights organizations that wanted to provide human rights assistance, essentially, and peacemaking assistance to designated organizations. First Amendment protected activity, we argued it was protected for about a decade in the lower courts. We won on that argument. We lost in the Supreme Court, and I think it's a terrible decision. But if you look at the actual enforcement actions of the government, who is it actually going after? So it has this incredibly broad power, and the Supreme Court, I think, wrongly blessed that very, very broad power to punish speech advocating lawful activities because it's associated with something we don't like. But who have they actually gone after? They've gone after people who have raised money for weapons, and they've gone after people who have gone over to try to fight for ISIL or to try to fight for Al-Qaeda. That's the vast majority of the material support cases. They are not going after people, for the most part, who are simply engaged in speech. And I think, in some sense, in our case, had, my client was Ralph Fertig, a 80-year-old guy at the time the court decision came down. He was the head of the Humanitarian Law Project. We brought a pre-enforcement challenge, which you're allowed to do, as you are, with respect to obscenity statutes and all sorts of other things. But had Ralph Fertig been sitting in jail after being prosecuted for advocating for human rights on behalf of the Kurdistan Workers' Party, I have no doubt we would have won that case. It would have been the exact same set of arguments. But Justice Kennedy and Justice Stevens, who both asked me during the argument, isn't this kind of an odd posture of the case? And I said, no, when the government criminalizes speech, it is well recognized that those who want to engage in the speech can go and seek a pre-enforcement challenge. That's true as a legal matter, but the optics of it were completely different. And so if they start prosecuting people for, writing things that that express their approval of particular groups that we don't like, then I think it'll be a whole new ballgame. I do believe that our First Amendment traditions are strong. As I argue in the book, it's the First Amendment traditions that make it possible for civil society to be as robust as it is in this country. But then the robustness of that civil society can, and I think will, stand up to threats to the First Amendment.
Ron Collins, I have a request and then a question. The request goes to the fact that the last 2 years, the work plan for the American Civil Liberties Union, for the first time in many, many years, if not at all, has not included any reference to the First Amendment and protections of freedom of expression.
We don't believe in the First Amendment.
So, to the extent that that's within
that's old-fashioned.
To the extent that that's within your bailiwick, hopefully the work plan for 2017 can put the First Amendment back in the work agenda of the American Civil Liberties Union, which I know it does, but it wasn't in the work plan. So that's the request. And the question is, one of the bright stars in our constitutional constellation was when the court vindicated the right of Jehovah's Witnesses to refuse to salute the flag. And I think we all agree that that was one of the high points in our constitutional history. How do you reconcile that principle with claims of religious freedom when it comes to what some would say, quote unquote, discrimination against gays on the basis when it comes to the marriage cases? And I don't say that as a rhetorical question. I think it's a tough question. I'm curious to or how you would how
So
you view that.
Yeah. So first of all, Ron, with respect to the ACLU's work plan, the work plan is a very long document, which I don't think you've read because it's actually not public, but I've read.
What do you have to hide?
And it's got it's got huge amounts of First Amendment stuff. What you're referring to is the centennial priorities. So we've prioritized 6 areas of work over the last several years, and they are. I'm not going to get them right now, but they're immigration, reproductive freedom, privacy and technology, LGBTQ equality, voting rights, and there's 6.
Mass incarceration.
Yeah, and mass incarceration.
I
yeah,
mention
thank you.
this only
Thank you.
because as
So,
someone who contributes to the ACLU, I get something that says work plan. That's what it
all
says.
right. Well,
And the last 2 years, the quote work plan that they send to those of us who contribute to the ACLU did not include any reference, and it said work plan, David. Believe me.
So Ron. So look, the idea is look, we have 53 affiliates with lawyers. We have a national project with lawyers. Many of them are doing First Amendment work on a daily basis. We have something like we have 1,400 pending cases at any time. I'm sure a big chunk of them are First Amendment cases. But the question is sort of what are the major what we decide when we decide our priorities is what are we represent a whole set of rights under the Bill of Rights. What are the ones that we feel are either most under attack and need most defense, or where there's real progress and real opportunity to continue on that front? So LGBTQ, real progress, real opportunity to continue on that front. Immigration, tremendous threats right now. Privacy and technology, tremendous threats, I think. And so, so if in fact President Trump comes in and makes the First Amendment, targeting his priority, I can assure you that it will become a priority, right? So we're responding to where the challenges lay. With respect to being required to service a gay or lesbian wedding on the same terms as you provide services to a heterosexual wedding when you object to gay and lesbian weddings, I don't see that as such a difficult case, because it seems to me that what it involves is an anti-discrimination principle. It's an anti-discrimination principle, right? A public accommodations law that says if you hold yourself out to provide services to the general public, you may not discriminate on the basis of a set of criteria. One of them is sexual orientation. That's a regulation of conduct. It's not a regulation of speech. It's a regulation of conduct. Now, if you have a particular ideological objection to that obligation to treat people equally, you don't have a right to exempt yourself from the prohibition on discriminatory conduct. If you're a business, you enter into business under the terms that the state sets forth, which are that you treat everybody. So I think it's a regulation of conduct, not a regulation of speech. It's not. If we pass laws saying people must, pledge allegiance to marriage equality, or people must, come forward and say, I support marriage equality, well, that would be a content-based analog to the flag salute. But this is an anti-discrimination provision. It's like Bob Jones University. Bob Jones University, they had a religious belief in segregation, and the government said, well, you've got to treat people without regard to race.
That was before RFRA, for one, the Religious Freedom Restoration Act, right? The Bob Jones case. But
what Bob Jones held was that it was also before Smith, the peyote case. So what Bob Jones held was that there was a compelling interest in prohibiting discrimination, and that overrides your personal objection to being to
Right,
to
but
obeying
but
a
federal
conduct
law though doesn't classify sexual orientation or gender identity as a protected status. So
No.
we're only talking about whether there is a constitutional argument against a state or municipal anti-discrimination law.
Well,
right?
sometimes you're talking. I mean, there are 20-some states that have state RFRAs, that have state analogs to the Religious Freedom Restoration Act, and that's often the context in which it
And
arises.
some of those states have already looked at that balance, and right. I mean, New Mexico, for example, right? They've looked at that balance already, and they've found their anti-discrimination law,
Thus
carries.
far, as far as I know, I think all the courts have sided with the principle of anti-discrimination over the principle that I get to exempt myself from an anti-discrimination law because I don't like the people who the law protects. And I think that's the right.
Okay, but that leaves more than half the states which don't protect against.
There's no there's no constitutional right to an anti-discrimination law, right? Private businesses, if they're not regulated by the state, can and required by the state not to discriminate, are free to discriminate.
Mm-hmm.
So it's the issue only arises if there's a state anti-discrimination provision. That's the obligation. But because that obligation is not focused on speech but on conduct, I don't think because someone in the same way that under the peyote case, the fact that you have a religious objection doesn't allow you to object to a neutral law of general applicability. The fact that you have a political objection doesn't allow you to.
May I ask a particular variation on the question?
Yeah.
So when the business, Anthony Dick, sorry, when you're holding yourself out to perform a service that's bound up with a type of speech, so for example, the artistic photographer, the florist, or the writer who's producing a piece of artistic expression that celebrates the marriage, do you think that changes the analysis?
I don't think so. Because I think the question is not what the individual is doing, but rather what the government is regulating. And what the government is regulating is the conduct of discrimination. So as applied to particular conduct, that conduct might have expressive characteristics, but all kinds of conduct has expressive characteristics, right? And what we generally say is that if the government is regulating the conduct, the government's regulation is generally permissible, subject to intermediate scrutiny under O'Brien. If the government's regulation is concerned with the communicative impact of the conduct, then we treat it as a regulation of speech, Texas versus Johnson, strict scrutiny applies. I think anti-discrimination laws, generally speaking, are regulations of conduct. They say that you must treat human beings without regard to the protected categories that they fit in, and so yeah, I don't think.
So even if that's coercing a message in support of something that the person finds morally abhorrent,
Like contraception in your health insurer or employer.
well, that's not a message.
So there too. I mean, if it weren't for RFRA, there would be no claim
Right.
with respect to. And even with RFRA, right? There's a question as to whether if there's a compelling interest, right? I mean, in the Hobby Lobby case, the court recognizes that there's a RFRA claim raised by the substantial burden on the corporation's religious practices, but then it says, well, there may be a compelling interest in providing women this protection. In this case, the United States was not able to show that it couldn't accommodate the religion and protect the women's unobstructed access to contraceptive, because there was this mechanism of just shifting the cost to the insurers, and because it was actually cheaper for the insurers to cover contraception than to cover pregnancy. It really wasn't imposing a burden on a third party, and so it was kind of it was a win-win situation. You could protect the woman's right, and you could accommodate the religious group's exercise. It's a tougher case where the question is, does our obligation to accommodate a religious group's exercise justify the religious group in essentially imposing costs on third parties, whether they be the women or whether they be the taxpayers? And the court in Hobby Lobby didn't have to address that because of the peculiar character of that situation. But in all the sort of free exercise jurisprudence that predated the Smith case, that the RFRA was designed to kind of revive it through statute. The court didn't permit people to, claim a religious exemption, which then, placed costs on third parties to protect their religious right, and it also didn't allow them to exempt themselves from generally applicable laws for the most part. So Scalia made that clear in a more formal way, but the results were not all that different. So my understanding is that although the Religious Freedom Restoration Act laws, these state RFRAs, read very strictly, right? They read, if anybody comes forward and says, this law burdens my free exercise, suddenly the government bears the burden of justifying its actions by compelling interest, narrowly tailored means, right? The most difficult burden to pass. But if you actually look, Chip Lupo has written a very good article of GW where he looks at all the cases in which the courts are actually applying RFRA, and they are not, it is not strict scrutiny like anyone has understood strict scrutiny. Maybe they're engaged in an act of collective judicial civil disobedience, but what they are doing is not applying strict scrutiny in the same way that the Supreme Court in the Sherbert versus Verner years was not in fact really applying strict scrutiny to these kinds of claims, because it would lead to what Scalia objected to and what the Supreme Court in the Reynolds case objected to with respect to the polygamy ban, which is every person is a law unto himself, because everyone can have a religious set of beliefs and can object to anything, and then suddenly you're going to give to the courts the power to decide under compelling interest whether any particular law on any subject can be justified. So I just don't think it's a sustainable principle. I think the courts have not really interpreted the law to lead to that result. If they did, I think those laws would get reformed.
Do we have another question from New York as we approach the end of our session? Mm-hmm.
Yeah, David, it's Floyd Abrams. Let's go back to Facebook again. Do you think Facebook should, in its policy of not carrying overtly racist speech?
Do I think it should change that policy?
Yes.
I don't know. I mean, I guess it. So it's a good question. Let me turn it around. Let me turn it around.
Imagine Facebook was a town called Skokie.
Let me turn it around. Right. No, but do you think, Floyd, do you think Facebook should adopt a policy which says it will not disseminate any untruthful statements?
No,
right.
But I think Facebook could play a role with respect to entities which on a pattern-like basis continually publish provably untrue and fabricate continually untrue statements.
And could bar them somehow? Bar them
from Facebook.
Yeah.
The word we used to call editing.
So I don't. I think I'm not sure where I come out on this, and I think it depends on whether you conceive of Facebook as more akin to a newspaper, or where of course there's editing, and of course part of their First Amendment right is to decide what will and won't be published, or whether you see them as a common carrier, as a platform, as a forum for expression, not a mediated forum for expression. And I think they're more of that. Now, could they shift into a mediated form of expression? I suppose. I think there are risks to giving them that authority. And and I think the risks are much greater if you talk about truth versus falsehood than if you talk about racism versus non-racism. But I think those lines are difficult to draw. And at the end of the day, I think I'm more comfortable with a kind of free and open platform than with giving platform owners the authority to stop conversations and to suppress speech. If you meet, your hypothetical, your counter hypothetical to my hypothetical, increases the threshold at which they would be able to act, and we all are more comfortable the higher the threshold is, and at some point it may well be justified. But I don't think it's an easy question at all.
With that, I'm going to now silence, I'm going to cut off free speech. Free speech is now ended for the evening because we're at the end of our time. But I want to thank David for putting up with my jibes as well as your serious questions, and Lee and Ron and the crew for sponsoring tonight's chat. So,
ladies and gentlemen,
here.
will you join me in thanking David Cole and Jess Bravin for this evening?
That was Wall Street Journal Supreme Court correspondent Jess Bravin and ACLU National Legal Director David Cole, with special guest appearances, of course, by members of the First Amendment Salon audience in Washington, D.C. and New York City. As I mentioned at the top of the show, videos and archives of past First Amendment Salons can be found within the Special Collections section of FIRE's new First Amendment Library, located at thefire.org/first-amendment-library. Included among the archives is a video of a salon from earlier this year featuring University of Chicago law professor Jeffrey Stone and Richard Posner, a judge on the United States Court of Appeals for the Seventh Circuit. I'll just say that Judge Posner made some headlines during that discussion, and you definitely won't want to miss it. The next First Amendment Salon will take place in April at the Floyd Abrams Institute at Yale Law School. The salon will feature a conversation between Floyd Abrams, an elder statesman of the First Amendment's legal community, and Adam Liptak, the Supreme Court correspondent for the New York Times. So stay tuned to So to Speak for what I'm sure will be a fascinating forthcoming discussion. And one final request. If you're thinking about making a tax-deductible donation before the end of the year, please keep our sponsor, the Foundation for Individual Rights in Education, in mind. This podcast wouldn't be possible without the organization's support. You can donate directly at thefire.org. This podcast is produced by me, Nico Perino, and edited and recorded by Aaron Reese. To learn more about So to Speak, you can follow us on Twitter at twitter.com/freespeechtalk, or like us on Facebook at facebook.com/so-to-speak-podcast. You can also email us feedback at so-to-speak@thefire.org, or call in a question for a future show at 215-315-0100. And until next time, thank you all for listening.